Okay. I will run through the logistics of today's webinar. So thank you again to everyone for joining us. This is part 2 of the Children's Rights Group's Children's Rights and the Law of Coronavirus. Part 1 is available for those of you who haven't seen it. Keelan will share the details there. And we've got 3 speakers today: Oliver Lewis, Marissa Cohen and Zimran Samuel. For those of you who haven't joined a Zoom webinar before, you'll notice that your cameras are off and your mics are muted. That is intentional. It's just to avoid any interference. So please don't be alarmed. You'll see that there's a Q&A function at the bottom of your screens. We would ask that you use that if you would like to ask any questions of the panellists, and they will be answered for you at the end, and any that we don't get to, we will try and pick up and respond to afterwards. We are recording the webinar, so a copy will be available after the event, but for now I will hand over to Keelan, who's going to chair today.
Hi everyone, welcome to our online seminar today. And welcome back to those of you who were here the last time for part 1. For those of you who weren't, as Shan has mentioned, you can access both the slides and the recording. They're on our website at the same link that the seminar for today is at, on our children's rights page and our events page. So do feel free to go back and take a look at those if you'd like to. For us on the children's rights team, it seemed to us that children's lives in the UK and across the world have been turned upside down by coronavirus. Their schools and their play spaces have been closed, their exams cancelled, their loved ones separated from them, and there's profound impacts on a wide range of groups of children, including some stories which we've seen in the last few days regarding increased risks in respect of trafficking, online child abuse and so on. And it seemed to us that children were in many ways the overlooked and forgotten victims of both coronavirus itself and the lockdown which we've seen in the UK and in other countries. And that's the idea of these seminars. It's to cast a light in an area where in fact there is not much light at present, and to look at the impact on children from a child rights perspective in a range of areas. So today we've got 3 superb speakers to hear from with a focus on 3 very particular areas. So we're going to hear about disabled children, we're going to hear about immigration and asylum, and we're going to hear from Zimran Samuel about abuse and domestic violence. That's the context for today. And we're conscious that in the audience today, we've got some people who specialize in one or more of those areas. And we also have many people who are child rights advocates from a range of different areas. Without further ado, I'd like to hand over to Dr. Oliver Lewis. Many of you will know of Oliver's superb work. And before returning to the UK Bar in 2017, Oliver had practiced in international human rights law for 15 years. So he's got extensive experience of using the law in a creative way in a range of settings, including in the European Court of Human Rights and before the UN. And he's put all of that background, expertise and experience to great use in being so creative in ensuring that the rights of children are protected in the UK courts, in the Court of Protection, through inquests in public law. And I'm greatly honoured to have him speaking to us today about the particular impact on disabled children. Over to you, Oliver.
I'm sorry, I had difficulties finding the unmute button there. Now that I got control over the slides, or at least I thought I had control over the slides. Good afternoon, everyone. Aoife Nolan started the last webinar that we held by setting out the international human rights framework, referring, of course, to the UN Convention on the Rights of the Child. And Keelan, in her presentation, reminded us that it was possible to supplement domestic legal arguments using international human rights law and standards, and indeed encouraged advocates to do so. She also made the point that the COVID crisis has caused a triple bind for children. First, it has exacerbated pre-existing threats to the realization of children's rights. Second, it's created new threats. And third, it's resulted in the removal of enforcement mechanisms to protect child rights. That is exacerbated, in my view, for children with disabilities. So I'd like to start my presentation just by drawing attention to the excellent UN policy brief on the impact of COVID-19 on children, I've just put a link in the chat room that you can click on if you want to have it on your screens. Zimran Samuel, who you'll hear from in a few minutes, and I discussed this policy brief in our blog. I've also put the hyperlink there, which we're going to update whenever there's a new set of guidance coming from one of the myriad international human rights bodies affecting children and coronavirus. So the UN policy brief, which is really worth reading, says that certain children are especially vulnerable or at least are placed in situations of increased vulnerability due to the coronavirus pandemic. And they include children living in slums, refugees, who my colleague Marissa Cohen will cover in her presentation in a moment, those living in places of active conflict, and children with disabilities and children in detention. And of all of these children, or in respect of all of these children, the virus has what the policy paper calls an uneven impact. So globally, children are at risk of falling into extreme poverty. And it's estimated that anywhere between 42 and 66 million children are at risk of falling into that category, which would be in addition to the 386 million children living in extreme poverty. And that's because income shocks at the household level, even if temporary, can have a devastating effect on children. And of course, children with disabilities are especially affected. And I note here the well-established bi-directional link between disability and poverty. Coronavirus is, we all know, exacerbating the learning crisis. And UNICEF has warned that children with disabilities may be at risk of exclusion completely from education if remote or distance learning programs are not accessible, or that they don't have assistive devices to allow participation and accommodate learning needs. And UNICEF has given some examples of assistive devices such as talking calculators, text magnifiers, alternative keyboards, and audiobooks. And my colleague Adam Wagner covered the situation on education in England in the previous seminar. A few weeks ago, we thought that the virus didn't really pose a risk to children's health, but actually we were wrong in two ways. Child health is affected both as a result of the global economic downturn and, of course, more recently we've discovered the emergence of a Kawasaki-type illness in children, and children with disabilities are especially prone to being exposed to people who might pass on the infection. We all know about the risks to safety, and if you didn't know about those, Zimran will cover those points in his presentation. One of my observations from having done a few cases in the past few weeks involving children and young people with disabilities and their families is that people with disabilities always seem to be an adjunct, an afterthought, an oversight, their needs and rights not being considered. And it's only when people with disabilities or their parents, in the case of children or young people, often exasperated, contact lawyers and put up a legal fight that policies are changed. And I talk here about young people as well as children, because for families with disabled children, the arbitrary 18th birthday of the child makes little sense, as I suppose it doesn't make sense for any children really. So I've been involved in, I think, 4 cases over the last few weeks, challenging, just as an example, the visits policies of hospitals and care homes and so on, both at the national level against NHS England and against NHS trusts, care providers and local authorities. And this is just an example of how children and adults with disabilities were an afterthought. So the starting point was more or less a blanket ban. And to be fair, the first 3 bullet points there that you can see were included in NHS England's visitor guidance. And the third one, especially important for parents visiting children in hospital. But little or no consideration was given to the adverse effects on people with disabilities. And I think it's genuinely come as a shock to some public bodies that the Coronavirus Act and related regulations do not, in fact, suspend the Equality Act. And you can see there the last bullet point, which NHS England added after litigation on the 8th of April, which has resulted in a trickle down to NHS trusts, who have also added an exception on their more or less blanket ban on visiting, which they describe as being on compassionate grounds. You'll notice there the very clumsy language insinuating that people with learning disability or autism have a mental health issue. But that to one side, the compassionate exception is all right, it's great, but it also misses the point that for many people with disabilities, they need an exception not on compassionate grounds, but on equality grounds. And so the latest litigation conceded by NHS England last week is on behalf of an adult with communication difficulties, and he has personal assistants who play an interpretive role for him. And so he's not someone with a mental health issue or learning disability, so didn't fall within the 4th bullet point. And NHS England have said that they will draft something to meet his needs and the needs of other people with communication disabilities. But my overall observation about how the government in the UK and around the world have made these knee-jerk reactions, sensibly maybe, in response to the coronavirus pandemic, but have done so with little thought about how that impacts upon people with disabilities. Another issue is the downstream effects of the government's unclear and, in my view, unsafe advice for care staff and the lack of testing for people in mental health hospitals, including child and adolescent units, as well as care homes. And that's meant that not only asymptomatic staff have carried on working, putting people with disabilities at risk, and there are many thousands of care staff off work with symptoms. So there's a depletion of care staff across the country. That's meant an increase of agency staff or no staff, and that's resulted in carers who don't know the likes, dislikes, and needs of disabled people. Yesterday, the UK Parliament's Joint Committee on Human Rights heard evidence by 2 mothers of young people with one has a learning disability and the other has autism, who are currently detained under the Mental Health Act. And they told the Joint Committee on Human Rights that because staff are stretched, there's a decrease in activities in those units. That in turn, coupled with the lack of regular visits by families, increases anxiety and self-injurious behaviour. That then leads to an increased risk that coercive measures such as sedatives, restraints and seclusion are used. And many families looking after disabled children in the community are also struggling, unfortunately, but carers are simply not turning up, or incredibly, they've been furloughed. As a mother put it in The Guardian last week, that has placed a huge emotional and physical strain on an army of unseen parent carers. Another mother looking after a young woman said that she usually has a team of 8 carers coming in during the week, but now she has none. So it really is a huge burden on people in the community, and civil society, and including lawyers, should be more actively in touch with families to represent them in challenging these policies and practices that violate their rights under the Human Rights Act and the Equality Act. So I finish where I started, which is that encouraging lawyers, families as well, and advocates to use international human rights law and standards to advance the rights of disabled children and young people, and to counter these knee-jerk policy reactions. So just a short reminder, I'm sure you all know that the UN Committee on the Rights of the Child published in 2007 a general comment on the rights of children with disabilities. It contains some really useful stuff that can be used. And of course, the CRPD, the UN Convention on the Rights of Persons with Disabilities, also covers children with disabilities and their families. and has some very powerful language on non-discrimination and the duties that states have to promote and protect the rights of children. Finally, in relation to the framework, the ever-evolving framework on disability rights, I've got another blog which you can all, I'll put the hyperlink in the chat room right now, which you can also see. That includes children with disabilities, and that's being updated whenever there's a new guidance or policy document from one of the international human rights agencies. Thank you very much.
Thanks very much, Oliver. And we're now going to hear from Marissa Cohen. She's going to speak about the impact of COVID-19 on children's immigration and asylum applications. And for those of you who don't know Marissa, she's a public law practitioner specializing in immigration law, community care and housing law. And she's got particular expertise in working with very vulnerable clients, such as those with complex disabilities, victims of torture, including sexual violence, victims of trafficking and exploitation. So we're going to hear from her with her perspective on children's immigration and asylum applications. Over to you, Marissa.
Thank you, Keelan, and thank you, Oliver. Hello, everyone. I hope you're all keeping as well as can be. I'm just going to sort out the slideshow a little bit. So, there we go. I hope you're all following that. So, just to, as Keelan mentioned, I'm going to be talking about the impact of COVID-19 on children's immigration and asylum applications. And I'll also be looking at the new procedure in the first tier tribunal and how that affects child appellants. So just to recap on some of the training that was given by Keelan and by Aoife in the first seminar, we know that COVID-19 has led to a disproportionate impact on migrant children, including school closures, changes to service provisions, and legal duties by local authorities. And coupled with that, limited oversight and intervention for children cared for by local authorities, as highlighted by Oliver, and effect on their mental health. Now, we know that each and every one of these issues is going to have an impact on children's ability to actually make their immigration and asylum applications and to progress them. In its statement on COVID-19 and its recommendations, the Committee on the Rights of the Child expressly recognised these disproportionate impacts, and they requested that government to protect asylum-seeking children and refugee children. And the manner of that protection was said to include targeted measures to protect children in vulnerable situations. And so what we see there are obviously positive measures to protect children, and not just negative obligations to refrain from harm. We also know that Section 55 of the 2009 Act places a duty on the Secretary of State to make arrangements for ensuring that when her functions are discharged for immigration functions, they are done having regard to the need to safeguard and promote the welfare of children concerned. And there are two issues that I want to deal with broadly, and I'm aware, I'm conscious that there will be many others, and I'm hoping that the Q&A after the seminar will give us an opportunity to flesh some of those out. Now, the first issue is the registration of children's asylum claims. As I understand it, the Home Office continues to insist on the lodging of asylum claims in person, and that obviously applies across the board to adults and to children. But obviously, it has a particular impact on children. Firstly, children are forced to essentially attend, to physically attend, but may not have a proper appreciation of the risks involved in attending. Probably worth noting that none of us have a very good idea, or none of us have a very good appreciation of the risks involved, for example, in travelling on public transport at the moment. But children are going to be even less aware of that. And migrant children, for example, for whom English is a second language, are going to have particular difficulties in assessing the same. A child is therefore forced to attend without a proper understanding of the risks involved. And secondly, for obvious reasons, an appropriate adult is required to attend with the child in lodging the claim. And the adult is therefore required to take on the risk both for themselves and for the child. The responsible adult will not necessarily be from the same household as the child, and that increases the risk for each of them. This requirement, this compulsory requirement that claims continue to be lodged in person, is also going to have a knock-on effect where the child is not able to physically attend to register their claims, either because they're not in fact able to get there, or because the responsible adult is not prepared to attend with them, understandably. Those children are going to have their asylum and immigration applications delayed. That could adversely impact on the substantive consideration of their claims if they turn 18 prior to the decision being made. Moreover, as we know, children are entitled to timely decisions as a matter of law. They are entitled to security and to stability. These matters are reflected in the Section 55 statutory guidance titled Every Child Matters. The second issue I wanted to explore is the new procedure in the first tier tribunal. We know that vulnerability changes everything. Vulnerability, including minority, changes everything in a case or in an appeal. It changes the instructions that we take, the way in which we take instructions. It changes the evidence which is required. It changes the time which is spent on a case. And importantly, it changes the procedure which the first tier tribunal must adopt in its determination of a vulnerable person's appeal. Now, a new Rule 4A in the amended 2014 procedure rules permits the tribunal to make a decision which disposes of proceedings without a hearing if the tribunal considers that 1, the matter is urgent, 2, it is not reasonably practicable for there to be a hearing, including a remote hearing, and 3, it is in the interest of justice to do so. And that is clearly a very far-reaching power on the part of the first tier tribunal, particularly when one considers the reasons why we have hearings in the first place. Together with that, the first tier tribunal has started issuing what we call generic directions in some appeals. These generic directions require, for example, an appeal skeleton argument to be filed and served, together with all of the appeal evidence to be filed and served within a relatively short period of time, for example, within 14 days of the date of the directions themselves. This is certainly a significant period of time prior to any substantive hearing being heard. These requirements or directions are clearly inappropriate in some cases, and particularly in cases involving vulnerable and minor applicants, where more time is needed, more evidence is needed, and so on. There is an important provision within these directions to apply for an adjournment, and that obviously must be utilised, but it does require a positive application. Now, the pilot practice direction for tribunals states that insofar as compatible with the efficient administration of justice, the tribunals should take into account the impact of the COVID-19 pandemic when considering applications for an extension of time for compliance with directions and the postponement of hearings. But that does not really grapple with a situation where the impact of the pandemic is simply not compatible with the efficient administration of justice. So what is missing? In my view, there has been a wholesale failure to grapple with the impact of COVID-19 on vulnerable applicants, including minors, in their immigration and asylum applications across the board. There has been a failure to issue guidance on certain principles on vulnerability, which must continue to be adhered to, and are all the more important in the present circumstances. And it's worth saying, in terms of this new approach, there will be cases where it will be beneficial for some applicants in certain cases. However, it is difficult to envisage that going beyond the most straightforward cases, which the Secretary of State has already conceded. So, what do we need to do? We have to go to the existing guidance on vulnerability and children. We have all heard it said, I think, that vulnerability is a matter for representatives. And that's not necessarily untrue. Representatives do have a vital role to play in the recognition of vulnerability in their clients. But it is not the case that it is a matter solely for the representatives. The overall decision on whether or not a person is vulnerable is ultimately the judge's responsibility. And in order to make that decision and to make related decisions, they have to take into account the evidence as a whole. That is not surprising, because it is the judge who is required to reach a finding on vulnerability, its impact on the evidence, and its impact on the substantive considerations in an appeal. And this is reflected in the Joint Presidential Guidance Note number 2 of 2010 at the top of the screen. And I set out some more sources on this page. It's worth reflecting on these again, I think, in light of these developments, which of course are changing all the time. In the case of AM Afghanistan, which I put at the citation at the bottom of the screen, remains a crucial decision of the Court of Appeal. It is particularly helpful in battling with the issue of effective participation in an appeal for children and other vulnerable groups, and highlighting the requirement on the tribunal, the obligation on the tribunal itself to consider this. Finally, I want to look at the case of VP, which is a judgment of the President of the Family Division, Sir Andrew McFarlane. And family courts, of course, have been one of the first courts to grapple with the tension between the best interests of children and remote hearings following the pandemic. It is available on Bailey, and it's definitely worth reading the judgment in full. And there are some points that are worth bearing in mind before we go into the main thrust of the judgment. So at paragraph 8, the President highlighted that establishing that a hearing can be conducted remotely does not in any way mean that the hearing must be conducted in that way. Although it seems like an obvious point, it does underline the need for proper consideration of whether a hearing really should be proceeding remotely. At 11, paragraph 11, the President highlighted that in that particular case, even in the nature of child abuse cases, that case was described as extremely complicated. The complexity will be familiar to immigration and asylum practitioners, particularly in cases relating to children, and particularly where there are adverse credibility considerations at play. And at paragraph 20, I think we have important recognition that asking a member of the solicitor's staff to sit in a room with someone who may have symptoms of COVID-19 is more than can be properly asked of anyone. And it seems to me this is something that can be applied across the board, from the application stage to the appeal stage. And it's helpful to have judicial recognition of this. Over the page, I've included some extracts from the judgment. At paragraph 24, the President highlighted the tension at play, which is namely the best interest of children to avoid delay and resolve issues affecting their development may be at odds with the need for the very resolution of that issue to be undertaken in a thorough, forensically sound, fair, just, and proportionate manner. At paragraph 26, just in the middle of the screen there, the President recognised the overwhelming importance of seeing all the parties in the case when they are in the courtroom, and held that a postage stamp image of any particular attendee is a very poor substitute for seeing that person fully present before the court. And again, that is really important recognition of the role that demeanour and appearance have in appeals or cases such as this. And at paragraph 28, the President highlighted that given the complexity of the issues, it was a prerequisite for the mother to have a full real-time ability to instruct her legal team throughout the hearing, and not just by a phone call at the end of each witness's evidence. And so therefore there has to be that proper consideration of how we are going to engage with our professional and lay clients during the case. So there seem to be three main issues when considering whether a remote hearing should be held. The first is the complexity of the issues at stake. The second is, can there be effective participation? Can the child access the hearing in a way in which he or she can understand? Do they have a computer with which they are familiar? Are they accustomed to video calls? Do they need an interpreter? Are we placing unreasonable demands and pressure on the child who may already be very anxious about their appeal? Does the child actually want to have their appeal heard remotely? Can his or her representative prepare properly in all of the circumstances? Is there a more proportionate alternative? And just to end on there, thank you very much for listening. I'll leave you with those thoughts, and we'll look forward to discussing further later on in the question and answer session. I'm going to hand over to Zimran now, who will be speaking about the impact of the lockdown on domestic abuse and violence.
Thanks so much, Marissa. That's great. First of all, can I just apologise to people for the technical issues? I understand it looked as if I was very good at ventriloquism when Oliver was speaking initially. And with Marissa, I know some of you couldn't see her at the start. So apologies for that, and we hope we've resolved it now. We're going to hand over to Zimran in a moment, but can I just flag, do use the Q&A or the chat function if you want to raise any questions, and we'll make sure that they get picked up in the Q&A session at the end. Now, to introduce Zimran, when we founded the Children's Rights Group, the idea of it was to be interdisciplinary and to focus on innovative legal advocacy in the courtroom and beyond, and trying to move outside silos of particular practice areas. And Zimran really embodies that, because Zimran himself is a bit of a polymath and quite interdisciplinary. He's got a very wide-ranging practice in child law, mental health, and international law. Many of you will obviously know him from his expertise in relation to FGM, his work on the FGM Law and Practice book, the LexisNexis book, and his work on international child law, child abduction, radicalization cases, and so on. But he actually does significant cases involving vulnerable adults and children in a large range of jurisdictions, including using the inherent jurisdiction of the High Court, the Court of Protection, acting in public law and family law. So we hope that that is a helpful way to think more broadly about ways in which we can protect child rights. Now, he's going to speak about the impact of COVID-19 and the lockdown on domestic abuse and violence. I'm just going to hand over to Zimran now, and I hope you'll be able to see him rather than Marissa when he starts. Thank you.
Thank you very much, Keelan. I hope everybody can both see me and hear me. It's a pleasure to speak to everybody this afternoon. I'm grateful for everyone who's tuned in, as it were. I'm going to be speaking about the depressing subject of lockdown and its effects on domestic abuse and violence at a time where I'm sure everybody who's part of this webinar will have heard the increasing reports in the media, on the newspapers about domestic abuse going up during the pandemic. And I want to speak a little bit about what some of that means in reality. We know that family stresses related to the pandemic, including job losses, anxieties over finances and health, have increased people committing physical violence between partners and between caregivers of children. School closures have not helped. A lot of the work that I do, that some of which Keelan's referred to, starts off life because a school teacher has reported it, whether that be FGM or another form of abuse. Often that's where things first start, with a referral to a local authority from a school. With that now not being possible, we've seen a huge amount of really, really difficult cases, which are now being reported often through charities when they're able to get through that information. And what I'm going to try and do is lay out some examples of some of the abuse cases that I've been getting and that have been reported to be on the rise by charities, with the suggestion that some of these issues will lead to some, sadly, long-term effects on children unless something is done to mitigate them nationally. So before I go straight into that, one thing to bear in mind is that this is a global challenge. This is not just affecting the UK. All over the world, we are seeing this as one of the effects of the pandemic. And I've provided a couple of examples there with the UN Secretary General calling it a horrifying global surge in domestic abuse, and that call being echoed by the UN Rapporteur for Violence Against Children and Women, and also by the UN Women Director as well. So there are plenty of statistics, and there are a couple of links which you can read in your own time, but the main point is that this is a global phenomenon. And what it means essentially in the UK, we knew early on from the National Domestic Violence Abuse Helpline that in the early part of the lockdown, calls went up 49% higher than normal after 3 weeks. During the lockdown, at one point, that helpline, which is run by Refuge, the UK's largest domestic abuse charity, reported a 700% increase in just a single day. So what's being reported to Refuge? These are some typical examples. We have the violence being experienced by children directly. And the types of examples that I'm been getting through Chambers is extreme forms of punishment as a result of parents or carents being stressed. As a society, generally, we are drinking more. And for some families, sadly, that's ending in violence, including violence against children. And those are the sorts of calls that are coming in quite a lot over the last 3 weeks. Also, children witnessing violence on one of their primary caregivers, either from the other caregiver or one of the adults that they might be in lockdown with. One of the unusual phenomenon that I found, and that's also been echoed by lots of charities and now the Deputy Children's Commissioner as well, is cases regarding children attacking their own parents, and include well, in which we're not talking about a toddler gently hitting his parent as part of a tantrum. We're talking about teenagers sometimes committing quite severe forms of violence under frustration and stress during the lockdown. And that's one of the things that, as I said, the Deputy Children's Commissioner has found to be on the rise as well. Lastly, and I think perhaps most concerningly, is emotional abuse and neglect. I say most concerningly because many of the victims that I've spoken to, indeed many charities such as Rise and other charities, are saying that one of the first things that people say is that they didn't seek help earlier for emotional abuse because they didn't know they were a victim. And it seems to my mind that there's still a lot of education or re-education in this area for people to know what emotional abuse may look like. And the myriad of different manifestations, the NSPCC has done research during the lockdown, finding that a lot of adults, I think they found 26%, wouldn't feel confident how to go about reporting emotional abuse, as opposed to when somebody experiences an immediate trauma, for example. Another risk is on the online risk as a form of domestic abuse. We don't often think about it like that, but children are online a huge amount during the current pandemic. It's sometimes the only thing that some children can do, and as a result, they're being exposed in some cases to sexual grooming behavior, and with images being disseminated perhaps more quickly than they otherwise might be disseminated. The UN Secretary General has again raised this as part of a global problem and has called on social media companies to step up their responsibility to protect the vulnerable. The only other thing I would like to say about that is a useful guide that I can refer you to from UNICEF, which I've provided a link on the 4th bullet point, and also a similar guide by the NSPCC. The latter I found particularly helpful when advising clients as to the very basic things that they can do if they're concerned about the possibility of an online risk. And I think some of the ancillary concerns related to that has been raised by charities dealing with revenge porn. Now, you say revenge porn is something that a lot of people have come across. It's not a term I actually like or usually endorse, but this charity uses it, and I'll use it for the seminar because it's the revenge porn helpline, which has increased, which has reported 200 cases in the 4 weeks of lockdown from 23rd March, and more last week, and so more the following week. So this is something which is being reported by charities as being on the rise. They're reporting sexting, they're reporting people taking images from each other when their couples might not be in lockdown together, and so text certain intimate images of each other. And then sometimes when a relationship has a strain and doesn't always last, those images are during lockdown conditions being disseminated. And that is a form of abuse, and it's not something that we immediately think of as something that might be on the up in lockdown. In fact, the Internet Watch Foundation, an organization that removes such images, has released an interesting statement saying that more needs to be done to protect the children from online criminals who are exploiting the current pandemic in this manner. Now, some of the work I've done traditionally has involved honor-based violence, and Keelan mentioned practices such as FGM and forced marriage. Now, a lot of those things happen across borders in many of the cases. In a typical scenario, somebody will want to go back to the home country, as it were, and for example, in the case of forced marriage, the marriage is arranged, and then the young person will not be allowed to come back to the UK until they've consummated the marriage and become pregnant. Now, that's often how FGM and forced marriage work. So one would expect that whilst we're not traveling, those issues would be going down. But this form of honor-based abuses are in fact still continuing, and there's been serious suggestions from frontline charities such as Karma Nirvana, and also international organizations such as UNFPA, that we will be seeing, in fact, these practices on the up. And actually, logically, it would have to think very hard. Why? Because many of these practices are already done in secrecy. They're already underground. So although people aren't traveling, the fact that the eyes of school teachers or social workers or other frontline practitioners such as medics might not be on children at risk in the same manner they otherwise are, means that these practices are seemingly flourishing in some cases indoors. So that's all a lot of doom and gloom. What can we do? Well, the family court, there's quite a lot of, that's been happening to deal with the upsurge in domestic abuse and violence, including the traditional forms of assistance that the family court can offer, and some of the most novel ways. So on a very basic level, non-molestation orders and occupation orders under the Family Law Act. These are very basic orders. Those of us that do family law will know that this is something that we can do quite quickly. There's no issue fee for people to worry about, and it's something that you can go to court and even in the remote conditions get within a couple of days, and sometimes a lot sooner in an emergency. Forced marriage protection orders are still available and under the Forced Marriage Act, and judges are carrying these out under the lockdown routinely. And in fact, if there's a real emergency, if you think you have a case where something needs to be dealt with, even in the evening or at night, those orders, like FGM protection orders as well, are operating out of hours as well. Now, the absolute nuclear button in terms of intervention from the family court are, of course, care proceedings. And what I'm finding is some of these issues mixed together, including quite severe forms of chastisement from stressed parents, mixed with other issues and other forms of abuse, are totaling into a way that the threshold for care proceedings is crossed within the lockdown, and there are being cases as a result of the lockdown being put before the court, which are Section 31 cases for care orders. That's helpful in a way, because that is sometimes the most powerful way to protect a child, including the ultimate way of protection is in extreme cases when a child needs to be removed from the family home. But it's also concerning because it's a time where we will be relying on the care system and children in care and care proceedings, but it's also as a time that we heard extensively last week of safeguardings duties being removed from those in care or being watered down significantly, adoption proceedings having serious question marks over them in terms of the compliance with Articles 6 and 8 of the CHR, and also care standards generally in care homes falling. If you're interested in finding out more any of that, please go back to our first seminar where we gave a little bit more detail about it. But the only point I'd like to make is this is a time that we will be relying on care homes and care proceedings quite a lot, and we need to protect what we already have rather than diminish it further. So that's all I wanted to say about domestic abuse and violence. I've been doing quite a bit of this work, a lot of it pro bono as well. What I found is that there's more of it happening now than I've ever found in the 11 years or so that I've been in practice. It's a very difficult time for many, many people, and often the solutions that we can give our lawyers are quite basic things that we can do quite quickly, which are not complicated legal things, and such as non-molestation orders. I've left the forced marriage unit's details there and a couple of other useful links. The forced marriage unit is still operating, so please contact them if you think you have a case or may have a case. And thank you very much for listening.
That's great. Thank you so much, Zimran. That's brilliant. So we've got about 15 minutes left, everyone, to run through some questions and answers. And do come back to us with more questions if you've got any. I'm just going to start off with 2 questions for Oliver Lewis. One is a point and one's a question. So the point is from Emma Johnson, who says that I'm an advocate in training and a parent carer. It's true that there is not the support there should be for families with children or young people with disabilities. So Oliver, if you could respond to that, and I'll give you the second point at the same time and you can take them together if you'd like. This is a question from Dragana Sirik Milovanovic, with my apologies for mispronouncing the name. I, of all people, should not mispronounce other people's names that are hard to spell. Was there any discussion on dangers of residential care for children in these circumstances? Can the situation be used as an argument for ending institutionalization of children? So a very big question there, Oliver. So could you answer Emma and Dragana's points?
Yeah, sure. Thanks very much for those 2 interventions. Emma, yes, I know, unfortunately that's true. There's nothing more I can add really, that apart from acknowledging that many families have been left completely unsupported, and Zimran's explained some of the consequences to that. So that is a huge problem. All I can say is maybe there could be some legal challenges. So if you're in touch with people in that situation, please advise them to get in touch with solicitors. If you don't know which firms to contact, then please feel free to contact us. Sian and our clerks can help if you identify the area of law. That's all I can say as a not very adequate response to that. And Dragana, hello, we've worked together for many years. That your point is a really good one, i.e., can we turn this into an opportunity to do some system reform, or at least advocacy towards that? I think that there's been more discourse in the adult arena than in children's rights about this, certainly in this country. Internationally, I think the institutionalization of children, disabled children, especially those with intellectual disabilities, is of huge concern. On my blog, I've listed all of the points at which international human rights figures and bodies and committees and commissions and so on have said anything about the heightened risk to people in congregate settings. That includes prisons, immigration detention centres, but also clearly social care institutions, psychiatric hospitals and so on. And the line from the international bodies is that if at all possible, move people out of congregate care, because obviously when you've got so many people living together, they're at an increased risk of catching the infection. And with regard to people with disability, they're at an increased risk, unfortunately, of having a more severe form of the infection because of comorbidities. I think in this country, there's been quite a lot of opposition to that line of thought, I should say. I can talk more with you about that offline, but certainly I think that in the international community, that discourse is starting to happen. The UN policy brief that I mentioned, there are sister policy briefs on disability and on mental health. And in both of those policy briefs, your point is made, right? So that comes from the top of the UN hierarchy.
Thanks very much, Oliver. That's great. We've got a question from Professor Aoife Nolan, who co-runs the Children's Rights Group. And this is another big one, along with ending institutionalization of children. And this is for all of our speakers. And the question is there any sense of the courts being more receptive to innovative arguments based on the UNCRC, i.e. beyond the Article 3 best interest principle, given the urgency of the issues being brought before the courts? I'm going to go to Marissa first on that question.
Thank you, Keenan. That's a really interesting question. I think absolutely. I mean, there should be scope. The UNCRC itself is referred to in that Joint Presidential Guidance Note number 2 of 2010 on the slide on existing guidance on vulnerability in children. And that's set out at paragraph 26. So there should be no barrier at all, because obviously what the UNCRC does is clarify the existing law and helps us to interpret it.
That's great, Marissa. Zimran, did you want to say anything on that question?
So the only thing I would very briefly add is that we've always been encouraged for many years in the family courts and children law cases to use the convention. I'm not sure why more of us don't use it, but I can remember even as far back as 10 years ago or more, Sir James Mumby, as he now is, and Lady Hale, and a lot of senior people saying, please use this. This is an international convention that you can put in your skeleton arguments and use with some force. During the current time when we're seeing rights curtailed, we should take up their call and absolutely use it. I haven't seen at the moment the courts dealing with them. That's because I'm not convinced we're making the arguments at the moment. And I think that as more of these cases now come before the courts, those of us that are dealing with whether solicitors or barristers should be brave enough to put it, the diminishing of the rights of children in care homes is a perfect example of that.
Thanks, Zimran. Oliver?
Yeah, I haven't seen any examples of the CRC being used, but I've seen, for example, the CRPD being used recently by Mr. Justice Hayden in the Court of Protection in a case called BP, where he cited Article 11 about the convention persisting in times of humanitarian emergencies and natural disasters. He also cited the European Committee for the Prevention of Torture's statement of principles on COVID-19, which is a really, really great document concerning any case about a place of detention. In all of those JRs that I mentioned, I always use, it doesn't surprise anyone to hear this, international law to supplement HRA, Equality Act, and other domestic law arguments. So I agree with both my colleagues that, yeah, international law should be argued more. And in the UK, it's interesting because just linking back to what Dragana said is that certainly with regard to the CRPD, the Disability Rights Convention, there's much less awareness of that convention in this country than in many countries in Central and Eastern Europe, for example. It's used much more over there at the grassroots level, or in India, for example, at the village level, as well as in the Supreme Court, for example.
Yeah, these are really good points. And just as the chair, if I can just flag one other thing. I mean, in a way, and it's something we've discussed in previous children's rights seminars, children's rights in England and Wales have in some ways suffered from the fact that there's such a strong legal framework under the Children Act, because you get people just running a point under, say, Section 17, Section 20 of the Children Act and not developing how the UNCRC rights and Article 8 of the ECHR apply in that context, because you've got a ready statutory framework to use. So I think in some ways the Children Acts 1989 and 2004 have resulted in some of us just taking easy statutory points and not necessarily making the more innovative UNCRC points that you would in other contexts where you were using the HRA as your primary focus. The next question we've got is from Helen Stalford, but just before going to that, we've had quite a few people ask us for confirmation that the slides will be available later. We're really conscious there's a lot to chew over in those very detailed, brilliant presentations we've had from Marissa, Oliver and Zimran, and I can assure you the slides will be available, and so will the recording afterwards, so don't worry if you missed out on any specific details. So the next question is from Helen Stalford to Marissa. And she says, has there been any thought to support or the impact of coronavirus on unaccompanied asylum-seeking children, particularly in relation to contested age and the potential for some of those children to age out of protection whilst assessments are delayed? So Marissa, over to you.
Thank you, Helen. That's a really good point. I think, obviously that is going to be an issue, and it's going to be really, really important to be right on top of it. We are talking about, we do have the Children Act kind of underpinning those assessments, and I'm not aware of what local authorities are actually doing. It sounds like from your question that they are trying to delay those assessments, and that must be challenged. Just sort of the usual basic principles in terms of not delaying protection and release for a child. I think there will probably be some quite interesting questions on whether interim relief should be granted to children. if there is any such delay, no matter how small, pending an age assessment. And I think the delaying of the age assessment itself must be challenged. So thank you very much for asking that question.
Really interesting question. Thank you, Marissa. And it does seem to me that line of cases, including the case of which looked at children who didn't have an assessment under the Children Act, and therefore didn't become looked after children for a period of time and didn't accumulate the requisite period of time to become care leavers, and that the local authority couldn't benefit from its own delayed decision making. Now that applies in circumstances where the local authority was wrong, and you can show that, but that line of public law cases might be worth looking at in this context, this different context too. Okay, we're quite close to the end. We've just got about 2 minutes remaining. So I realise some more of you may have questions, and if you do, or if anything occurs to you later, please do get in touch with us. We're really happy to pick up questions at a later stage. I'd just like to ask each of our panellists if they've got any final additional thoughts after the discussion in the running order that they spoke in. So starting with Oliver Lewis.
Final thoughts, please keep the conversation going. This is not simply a webinar and we're all going to go away. So please keep in touch with us. All of us are very happy to have informal discussions over email, over telephone, without the need for a formal instruction. So please keep the conversation going and give us feedback on this seminar and any other topics that you'd like us to cover. Thank you.
Great. And Marissa?
Thank you, Oliver. I think, I mean, one thought that sort of strikes me particularly, in relation to this unaccompanied asylum-seeking children point, and underlying all of the issues, is that time is going to be the real sort of decisive factor here. It's going to be really important to act quickly. I mean, already, I think it's been highlighted across the board that there has just been a failure to really grapple with the impact on vulnerable children, and just on children alone. And that's obviously, and it's important, but obviously we are starting to grapple with that now. And I think it's really important to kind of match that with some cases and just really kind of get that going in the legal course and in the tribunal, of course, as well. Just in terms of the unaccompanied asylum-seeking children point, just briefly on that, that there's been development on the application of the benefit of the doubt point, and I do wonder whether that's something that could be looked into a little bit more, particularly if you're going to have a situation where the assessment may be delayed and it may prove really quite difficult to proceed with it. The child might not want to have it remotely to the child, for example, but you may also have a situation where there's going to be a delay in evidence gathering, and in those situations the parties are really going to have to put their heads together and really think about whether this is a case where the benefit of doubt can be sort of fleshed out a little bit more.
So the only thing that I would add is that this is obviously a depressing time for anyone dealing regularly with domestic abuse or violence, and also for difficult for a lot of lawyers that have to deal with those tragic stories as well. Two things I'd like to finish by saying, of course, this is an important time for strategic advocacy when we're seeing rights diminished in this area across different issues that we've discussed over the last two seminars. And it's a time for those novel arguments that we've talked about and the use of these conventions. But the vast majority of people, actually the solutions they need don't come under that. Most people will need quite basic injunctive relief quickly, and that's something that all of us, all solicitors and barristers, can do, whether you've practiced in this area or not before. Getting out a non-molestation order is something that any of us can assist with, and I think that's the sort of thing that most people will come forward asking for help with. If there are any other questions, if someone thinks that they might have a case they need help with, please do get in touch with us. Thank you.
Thanks so much, Zimran. And can I just emphasize, as Oliver said, about keeping the conversation going, the idea of this seminar series has been to cast a light in areas that are otherwise being forgotten. So if you in your work, and there I'm getting some children's rights heckles in the background from my own family, If you, in your own work, think there's any area of child rights that's being overlooked, or you think we would benefit from doing a seminar on it, please do get in touch with us and let us know. And finally, one of the very odd things about online seminars is that you get brilliant presentations like the 3 we've heard, and there's no applause. So I know all of you are muted, but I'm not. So I'd like to finish the presentation by clapping Marissa and Oliver and Zimran for really superb presentations and thought-provoking presentations. And thank you for joining us today.